Sackett versus Environmental Protection Agency is the latest chapter in the long-running saga of how to define the waters of the United States under the Clean Water Act. Chantel and Michael Sackett bought a residential lot in Bonner County, Idaho over 15 years ago near Priest Lake. While making initial construction preparations, the Sacketts received an order from the U.S. Environmental Protection Agency accusing them of violating the Clean Water Act. According to the EPA, by depositing dirt and clean fill onto their property, the Sacketts had unlawfully discharged pollutants into a water of the United States without a federal permit. The Clean Water Act prohibits the discharge of pollutants, including dirt or clean fill, into the navigable waters of the United States without a federal permit. The Act further defines navigable waters as the waters of the United States. For decades, courts have recognized that this definition extends beyond those waters that are navigable in fact. But there is a long-running controversy about just how broadly this definition extends. The EPA and the U.S. Army Corps of Engineers have defined waters of the United States quite broadly. Federal courts, however, have not always agreed with the agency's broad assertion of their own authority. In Sackett versus Environmental Protection Agency, the Supreme Court was unanimous in its judgment, but quite divided on the rationale. Justice Alito wrote the opinion for the court. Justice Thomas, joined by Justice Gorsuch, wrote a concurrence. Justice Kavanaugh wrote an opinion concurring in the judgment that, while styled as a concurrence in the judgment, reads a lot more like a dissent because it challenges the majority's interpretation of the Clean Water Act. Justice Kagan also wrote a separate opinion concurring in the judgment, joined by Justices Sotomayor and Jackson. Justice Alito's opinion for the court in Sackett explicitly embraces Justice Scalia's plurality opinion from the Rapanos decision. This means that wetlands that have a continuous surface water connection or that are directly adjoining jurisdictional waters may be regulated as part of the waters of the United States. But those wetlands that are physically separate from such waters may not be. The Clean Water Act extends to only those wetlands that are, as a practical matter, indistinguishable from waters of the United States. Justice Thomas concurred separately to suggest that a fuller examination of the scope of federal regulatory authority might require more dramatic limits on the authority of the EPA and Army Corps of Engineers. Whereas Justice Alito's opinion for the court focused on the meaning of the word waters, Justice Kavanaugh's opinion focused quite a bit on the historical practice of the regulatory agencies. Wrote Kavanaugh, "The court's test narrows the Clean Water Act's coverage of adjacent wetlands to mean only adjoining wetlands. But adjacent and adjoining have distinct meanings." Justice Kagan's separate opinion emphasizes some of the same points as Justice Kavanaugh's opinion and criticizes the majority opinion for not placing sufficient weight on the Clean Water Act's reference to adjacency in other portions of the Act. The Sackett decision is quite significant, particularly for federal control of land use. How many wetlands are regulated going forward will depend substantially on the choices made by state and local policymakers. Further, this decision may encourage greater consideration of non-regulatory ways of conserving wetlands, such as the various incentive-based programs administered by the Departments of Agriculture and Interior. Much as Congress has turned to fiscal tools to address concerns like climate change and greenhouse gas emissions after the Supreme Court's decision in West Virginia versus EPA, we could well see a similar shift towards the use of fiscal tools, tax incentives, subsidies, and the like, to encourage wetland conservation in the wake of Sackett. As always, only time will tell.